Okay, this is Julio Zamora. I'm making a notation for for a statement in Workman's Comp settlement hearing in Judge Grill's court, administrative judge. This is dealing with the union. These statements are related to disability, by the way. Okay, because I have to read these statements because the union said I could pursue it under Workman's Comp because they denied me arbitration. So I'm going to go to Article 25, Discharge and Disciplinary Procedures. Okay, and it says the company may discharge or otherwise discipline an employee for just cause. The company shall not proceed with any interrogation unless the employee being interrogated is provided with union representation, unless specifically waived by the employee in writing with a copy to the local union. Okay, and that never happened. I was interrogated by the dispatcher and there was no representation, and he told me that the shop steward was on his way and to sit down. And I should also remind the court that I had to take a panel hearing on severe profound hearing impairment, and I was found to be deaf and more than 50% hearing loss in both ears. Okay, so there was no representation on December 7, 2010. And then it goes on to say that the suspension and discharge notices must be issued to the employee, with a copy sent to the union by certified mail within 20 calendar days, or the event giving rise to the violation or when the company obtains knowledge thereof. Okay, and then it goes on to say for suspension or discharge. For suspension or discharge must be sent and postmarked to the company within 10 calendar days of the union's receipt of the notice of offer of suspension and discharge. Notice of suspension and discharge. Within 10 calendar days of the union's receipt of the notice of suspension and discharge. If the company fails to send such notice within the time limits, the right to suspend or discharge is waived. I should note also that the Safeway and Tracy Distribution Center in Tracy, California, filed a grievance, and it was received by Local 439 on December 17, 2010. December 17, 2010, the union received a grievance filed by Mr. Mike Sadler. The letter was dated December 16, 2010, and the local union received it on December 17, 2010. Okay, and they violated the time limits, and the discharge is waived. Okay, but that didn't happen. And it goes on to say on Step B, Article 25, any employee shall be discharged. Any employee shall not be discharged unless he has had one previous written warning, excluding production and attendance, with a copy to the union for any offense committed within 180 days prior to discharge, except in the case of discharge for dishonesty or theft, any violation of the company drug and alcohol policy, including the sale or use of any alcohol or controlled substance. Okay, well, we know there wasn't a drug and alcohol offense or anything else. Okay, and it says it shall not be discharged. And I never had one previous written warning. I had no warning whatsoever that I was going to be discharged on December 16, 2010. And the grievance wasn't filed within 10 days. It was received on December 17, 2010. Okay? And Mr. Nightstronger replied immediately on December 17, 2010 that the disciplinary action to be denied and that the grievance to be returned to work immediately. And I should also note that they were asked to set a date and time for a hearing. And the date was set by Mr. James Williams, Transportation Manager, for January 11, 2011. I should note that's more than 30 days. I should also note that James Williams, Transportation Manager, was notified to send all documents and evidence or whatever he may have to prove his accusations or his right to discharge or whatever, disciplinary action. I should note that Mr. James Williams, the Transportation Manager, didn't do anything. He didn't do anything in 10 days, he didn't do anything in 20 days, and he didn't do anything in 30 days. Okay? So I should note that. And also I should note that there was no Board of Adjustments. A Board of Adjustments is a panel set up of no management personnel being present. There has to be an arbitrator there that's neutral. But no management or supervisory personnel are to be present at the Board of Adjustments. I'd like to make that clear. Okay? So that never happened. There was no Board of Adjustments, and my case for discharge or whatever should have been heard within 30 days to make their discharge valid. Okay? To make the discharge valid, they needed to confront the Board of Adjustments, and nobody from management or supervisory personnel are to be present at the Board of Adjustments. Okay? And I should also note that the Board of Adjustments, when they make their decisions, they don't have to make it known. But the company will be notified that the discharge or suspension was upheld by the Board of Adjustments and signed by the arbitrator and the people that had attended the Board of Adjustments. There will be signatures. Now, Safeway and Tracy, the distribution center, James Williams, the terminal manager, didn't produce no such document signed by the Board of Adjustments, arbitrator or whoever was present, that the discharge was valid. That the discharge was valid. Okay, so if Safeway and Tracy Distribution Center in Tracy, California is saying that that I was discharged, it's an invalid discharge. It wasn't backed up by the union contract or contractual procedure. And they need to produce that, plus they have to send 2 registered mail to establish the fact that they filed agreements for suspension and discharge within 10 days. Within 10 days, suspension and discharges. And the time limits weren't met in 10 days, 20 days, or 30 days. Because they set up a panel hearing, not a Board of Adjustments, but a panel hearing, which is not valid because they need to go to the Board of Adjustments for suspension and discharges. And arbitration. The document needs to be signed by an arbitrator. And who attended the Board of Adjustments? No one from management or supervisory personnel can be present. Okay, we should make that clear. The company didn't do that, so there was no ballot of discharge on December 16, 2010. There must have been a misunderstanding with the union attorney and the BA. Mr. Neiswanger. And I should also note the fact that when they had the panel hearing, even though they didn't go to the Board of Adjustments, and why they heard the panel hearing, what subject did they hear for, I don't know. It wasn't about the discharge, because it needed to go to the Board of Adjustments in front of an arbitrator. And a decision was to be made whether the discharge or suspension was valid or not. Okay, and it wasn't done. So there's no valid discharge from Safeway Tracy Distribution Center from James Williams, the transportation manager. He did not respond in 10, 20, or 30 days, and he he violated the time limits, and he didn't produce any evidence or documents, etc. by December 25th, 2010. That's my statement for workman's comp, Judge Grill's court. Unless they can produce a document from the Board of Adjustment signed by the arbitrator and the people that were present, excluding the management personnel from Tracy, Safeway, Distribution Center, and supervisory personnel. They are not allowed to be on the Board of Adjustments. Now, so we know that the discharge was invalid. And going further with this, we should also note to the fact that I was sent home on December 7, 2010. Flat out sent home because I received a notice of offer of work on December 1st, 2010. I went to work on December 3rd, 2010. I was flat out sent home on December 7, 2010. And I had nothing in writing, and I had no representation, and nothing was said to me on who, what, where, when, and why was I sent home. And there was and the statement on the following of this statement will explain why that they didn't respond within the time limits, etc., including the falsification or altering of documents by the dispatcher at Safeway Distribution Center in Tracy, California. Okay, and their phone number is 1-800-388-2125. If anyone cares to verify my statement to be true and accurate about the Board of Adjustments. Did they or did they not have a Board of Adjustments within 30 days? Did they or did they not send a registered mail to the company, to the union, within 10 days, or to Julio Zamora at 1385 El Camino Way, Los Banos, California, 829-1787, area code 209. I never received any said document, and there was no Board of Adjustments, and there was no decision whether the discharge was valid or not valid, because the discharge is not valid because they didn't meet the time limits within 10 days or 20 days or 30 days. They didn't respond, period. Not with evidence, documents, or anything else. In fact, they didn't, for a matter of fact, they just sent me home, and they haven't paid me every week or every 2 weeks on the notice of offer of work, which shows that I have a permanent disability. And by sending me home, they should have gave me disability payments. And I was on FMLA, which I was denied medical treatment. That'll be my beginning statement at Judge Grill's Settlement Conference at Workman's Comp in Stockton, California. And a notation.